Well, good afternoon, everyone, or good evening, depending on your time zone, whether in North America or Europe or otherwise. My name is Brent Holman, and I'm the Deputy Commissioner at the Office of the Privacy Commissioner of Canada. But I'm here today as co-chair of the Global Privacy Assembly's Digital Citizen and Consumer Working Group, or the DCCWG. And I'm joined today by an expert panel that I will soon introduce on a very pressing issue. When regulatory worlds collide, the intersection of privacy, consumer protection, and competition. I would like to express my gratitude to and our gratitude to the organizers of the CPDP, especially Mr. Dara Halinen, who made it possible for our working group to organize this session. And it's the host of this session, the Digital Consumer Working Group. Since 2017, we've been exploring one of today's most impactful regulatory developments, that being this intersection of privacy, consumer protection, and competition. For our working group, we're currently exploring the complements and the tensions between the objectives of privacy protection and antitrust, as well as engaging in the sensitization of other forums, including through this event, of engaging key cross-regulatory partners and audiences on this reality, so that competition authorities can recognize a privacy issue when they see it, and vice versa, privacy authorities can recognize a competition issue when they see it, all with the holistic goal of facilitating greater collaboration amongst regulatory spheres to the benefit holistically of consumers and citizens around the world. So environmentally, we are all witnessing how consumers and businesses continue to develop technologically driven commercial relationships, and with personal data increasingly representing the currency of digital commerce, this overlap of spheres has become more apparent than ever. Regulators and global networks have been living and examining this intersection of regulatory spheres for years now, and privacy and consumer protection regulators are increasingly taking enforcement actions over the same privacy-related conduct. And this really takes us to today's expert panel, who will be sharing their views and discussing this intersection phenomena from multiple vantage points. Because to really appreciate a statute and understand a statute, you must view it from all angles. So we're fortunate to have a very diverse panel in terms of geography and stakeholder representation. So I will introduce them now. First off, we have Dr. Anna Collapse, who represents the regulatory perspective. Anna is a member of cabinet at the EDPS, advising on protection of rights in the digital sphere, privacy and competition, online manipulation, scientific research, and ethics and innovation. With a PhD in European law from the University of Naples, her research has focused on the intersection between data protection, privacy, and competition law in data-driven markets. We also have, for the academic perspective, Erica Douglas, a leading academic from Temple University School of Law in Philadelphia. Go Owls. Professor Douglas's scholarship has focused on the intersection of antitrust, data privacy, and intellectual property, with a particular emphasis on the application of legal theory to new technology. She's been widely published in various journals, including Yale Law Journal Forum. And prior to joining Temple, Professor Douglas practiced antitrust law in the Silicon Valley. Now, let's turn to the private sector perspective. We have first Ian Cohen, a leader in building online businesses. Ian has been a consumer data and privacy advocate for over 20 years now, and he currently serves as the CEO of Locker, a privacy management platform seeking to empower enterprises with visibility and control over data being shared with third-party applications. He was also the CEO of Credit.com, which was a free online service garnering 5 million visits per month. And then finally, to round off and close things off, we have the legal advisory perspective with Alan Tomas, from Brazil, which, as we all are aware, has a very newly minted privacy regime in that jurisdiction. So Alan is the founding partner of CT Campos Thomas Advogados and has over 12 years of experience advising high-profile national and international organizations on technology and digital services, privacy and data protection, international property, and venture capital. He is also the CEO of ATEC Privacy Center, an educational center providing advice on privacy matters. So what we're going to do, each of the panelists will share with us their initial thoughts regarding this subject, after which I'll have a few questions for the panel and followed by opening it up. And if there's other questions in the chat, please do share them and we'll try to get to as many as we can in this session. So with that, I'm hoping to start things off by turning it over to Anna to share with us the regulator's perspective on the intersection. Anna, the floor is yours.
Hello, everyone. Thanks, Brent. Thanks to the OPC for the invitation to join such a crucial discussion today. So my intervention will revolve around 3 main points to which I will turn straight away. My first point is about why we're even here, why we're having such a discussion and why this debate has started. And it has a lot to do with the dominant business model and with the endemic trends that we observe in the digital ecosystem. In other words, we are here because of some specific features that we observe in the digital economy. So I referred to that, the dominant business model, which is based on pervasive profiling of individuals or tracking, if you like. Data is the object of such tracking, but there is more at stake. There are our thoughts, our desires, our hopes, our fears, and inclinations. As EDPS, we've been vocal, extremely vocal, on how this business model has been putting our rights and freedoms under huge strain. This is a business model which no longer and never was sustainable. Moreover, there are worrying and harmful trends which really pervade our digital ecosystem and sit at the crossroad of multiple disciplines and fields of law. These trends or systemic failures really emanate from the business model that I refer to. And I will name a few, only a few, because we have limited time. Imbalance of power and imbalance of information between, from one hand, a handful of large, powerful players, and on the other hand, the people. Insufficient transparency and accountability, growing inequality in the distribution of value creation, manipulative and addictive patterns, but also I'm thinking of the role of platforms as gatekeepers for solution, choice, and innovation. And finally, online disinformation and manipulation. Unless big tech makes a U-turn here, some of these trends will even be amplified during situation of crisis or uncertainties like the one we live. And I'm thinking in particular about, especially of vulnerable groups and vulnerable people. These are times where we should not lose sight as regulators of those endemic issues. My second point is that the direction that the digital ecosystem is taking and that we are observing is harmful both at an individual level and at a societal level. People suffer at a dramatic lack of control over what's happening to their digital experiences and lives. Think of manipulative design or addictive design paired with, and I'm using an euphemism, paired with a dominant position in the market or with a conglomerate position in the market, with a monopolistic position. So the chances for any meaningful deliberation, determination of the self are null. And this is just an aspect. From a much broader societal perspective, we observe chilling effects on choice and innovation, freedom of expression, and ultimately on the democratic tenure of our societies. In other words, there are huge costs that societies bear in exchange for the attention economy services. And there is an interesting development that civil society, academia, and many more actually are turning their attention to, and that they are pointing at, I think, these days. An interesting analysis of how big tech is evolving in the ways they exert their power. And what they claim is that those companies, and I think it's very interesting, that those companies not only occupy the rules of the game of public spaces, such as the one where freedom of information takes place, also increasingly acting as real public infrastructures which have become indispensable to us, and that they increasingly represent the gateway to our single gateway for our digital lives that these days sadly means our life, full stop. So these implications, I think, should be carefully analyzed, also because as is been raised during a morning panel on exposure notification, infrastructures are really difficult to control. So we said as EDPS something also more specific this year. We've been warning that the global crisis, such as the pandemic, actually risks being an occasion for some to expose some of attributes extremely years ago. Today, when we EPS the opinion and voiced our concern in
Yeah, so it seems that we're having some connection issues with Anna, but before we lost some of the connection, she certainly was sharing some very, very compelling points about this phenomenon of the intersection. She talked about chilling effects and on choice, innovation, and ultimately democratic rights. The challenges associated with addressing and managing infrastructures and how difficult they are to control, and how they might kind of create the conditions for this type of market power. And interestingly, and most timely, with respect to how the pandemic may have presented itself as an occasion for organizations and enterprises to expand their position of market power. So with that, I think what we'll do is move over to Erica, who could share some of her opinions and views from the academic perspective. Erica?
Thank you so much, Brent. And I hope in the discussion we can finish your thoughtful remarks. It's a pleasure to be here to discuss these issues, which I believe also are quite important with our panelists and our guests today. So much appreciated. I think Anna did a fantastic job of introducing the privacy side. What I want to do with my remarks is introduce to a privacy audience the sort of antitrust side of this. And so first, I'll describe to you the perspective of antitrust agencies and scholars about how data privacy fits into antitrust law. And second, I want to submit to you that the way that we've framed that intersection so far is somewhat incomplete. So if I could get the slides out. There we go. Great, thank you, Samuel. So this Venn diagram is how we classically perceive the interactions between these areas of antitrust law, data protection or privacy law, and consumer protection law. And this diagram comes to us courtesy of the Australian Competition Authority's Digital Platform Inquiry's final report in 2019, though a similar diagram appeared in the EDPS report on big data. And I've added a red box up in the top left to indicate sort of where we are today, discussing the competition and privacy interactions. And I think the important thing here is that at a macro level, the goals of antitrust law and data privacy law are typically cast as harmonious or complementary, because modern antitrust law seeks to improve consumer welfare through competition. Competition is thought to achieve higher outputs, better quality, lower prices, all to the benefit of consumers. And then in the data privacy diagram, we have at the highest level of abstraction, really data privacy protecting consumers by enabling control over their personal data. And since protecting consumers' welfare, the tendency is to emphasize sort of a compatibility and complementarity here. And you can see that in the most common example used to describe this interaction by agencies, which is data portability. The idea here is that data portability rights would classically be viewed as promoting competition because in theory, they enable consumers to switch services and bring their data with them. So in the most common and widely accepted antitrust theory, which is shown on the slide if we could, it portrays data privacy as an element of quality that improves with competition. And this has sort of become the paradigm that is most widely accepted in thinking about how antitrust analyzes these issues. And this privacy as quality perspective really plays both an integrating and a limiting role between these two areas of law. So first, it's integrating by situating data privacy within the existing consumer welfare frameworks of antitrust law, treating it like other factors that might influence competition when we analyze mergers or conduct cases. And the classic example here is in merger review. So if you imagine that pre-merger, two instant messaging services compete to offer consumers greater privacy or security for their messages, then privacy might be considered an important parameter of competition. When firm one offers better privacy features, say ephemeral messaging, it pushes firm two to do the same. And so consumers benefit from that privacy-based competition. Turning to the antitrust part of that, in merger analysis, antitrust authorities might consider whether that competitive pressure will be lessened by the transaction that merges together the two previous privacy competitors. If that's likely and not offset by other effects, they may find that antitrust authorities choose to challenge that transaction. And you can see this sort of thinking in the European Commission's review of the Microsoft LinkedIn merger. It involved this type of analysis around professional social networking and the privacy impacts that arose from that merger. So the second role of this privacy as quality view, I submit to you, is actually to act as a limiting factor. You can see that up on the slide here. So it both integrates and limits because it acts as a limitation on the jurisdiction of antitrust agencies and the application of antitrust theory. Because if we change the facts in my messaging merger example to instead find no privacy-based competition between the merging parties, then other privacy concerns that might flow from that merger have been viewed as beyond the scope of competition law to address. Instead, they're directed as matters for data privacy law. And an example of this that has come up again and again is consumer privacy rights advocates seeking to have the FTC intervene in mergers like Facebook WhatsApp or Google Fitbit based on what we might call pure privacy grounds that are unrelated to competition or economic efficiency concerns, generally about the combination of data. And the FTC and other antitrust agencies have viewed those pure privacy issues as beyond their jurisdiction because there wasn't privacy-based competition that particularly characterized the relationship between the merging parties. So in all of these examples, antitrust is being cast as harmonious or complementary, that competition would rise or fall along with privacy. And if we could get the final slide up here, I submit to you that this complementarity view is incomplete. I argue in the recent essay in Yale Forum that by focusing on complementarity, antitrust theory has under-acknowledged the potential for tension between competition and data privacy, particularly in the digital economy. It may be that most or many interactions between antitrust and data privacy end up complementary, but those that aren't are complex and they're much less addressed in existing theory. And so this slide presents to you a couple of areas where tensions or trade-offs are emerging between data privacy and competition, where the theory of complementarity that predominates this discussion is essentially giving way to a reality of interactions in the digital economy where there is not complementarity. So we'll talk about each of these briefly. The first is that dominant firms are invoking data privacy as justification for alleged exclusionary conduct. In antitrust law, where conduct is subject to a rule of reason standard, the defendant can escape liability by providing and proving that it had a valid business justification for engaging in the alleged conduct. User privacy protection is being claimed as this type of justification. And I'll give a recent example of this, though there are many. The European Commission is investigating Apple's App Store rules. There have been several complaints alleging that the rules Apple imposes on third-party apps are anti-competitive. And one example of this that highlights the potential privacy tension is Tile's complaint. Tile is a location tracking app and device company. And it complained that Apple favored its own location tracking app, which is called Find My. Tile competes with Find My. Both offer users the ability to track important items like keys or wallets, and both depend on user location data. But Apple required Tile, a competing app, to use the default off setting for location tracking, while Apple's own app was permitted to use a default on setting. We know that users tend to accept default settings, so this seemingly small difference makes it easier for Apple's app to obtain location data. But Apple argued that this disparate treatment was merited because of differential data privacy and security risks between the Tile app and its own app. Apple stores data locally, Tile doesn't, and they argued this necessitates different user settings. So here we see Apple casting itself in a role that it plays of user privacy protector, safeguarding sensitive user location data from third-party apps, even where that role also provides Apple with a competitive advantage. And we can see similar tensions arising in things that have been discussed at this conference, like Google's plan to terminate third-party cookie access. The walling of these technological gardens, in other words, presents both opportunities to improve privacy and opportunities to reduce competition. And these scenarios do not fit into the narrative of complementarity that we've been presented with here. So the final thing I wanted to talk to you about was another example, a second area of emerging but largely unaddressed tension between antitrust and data privacy, and that's data access remedies. In antitrust theory, access to data is increasingly becoming a focus and cast as essential to competition. And that's something we could argue over separately, but that is the case for a lot of the theories that are arising. And the result of that is antitrust scholars and agencies are calling for antitrust remedies, legal orders, that would compel access to or disclosure of data from digital platforms. And that mandated access is cast as a means of restoring online competition. But digital platforms often compete using our data, as Anna nicely framed. And in other words, our data has become competitively valuable in the digital economy. And antitrust theory hasn't addressed how compelled access to personal data will be reconciled with the new reality of data protection law. It means asking about the scope of consumer privacy rights and whether they reach those types of remedial disclosures, and whether consumers would or could consent to such remedies. So again, we see a scenario of potential tension. So in conclusion, I think antitrust has cast this area of law as largely complementary. I submit to you there's growing potential for non-complementarity, and that addressing that non-complementarity is essential to creating cohesive digital regulation across these regulatory spheres. And it's not so simple as either privacy or competition, but ideally finding solutions that can enable consumers to maximize both. Thank you.
Well, thank you very much, Erica. So I think at this point I will just move along to Ian and the sharing of Ian's remarks, and I'll let the audience know that we will be cycling back with Anna Claps at the end now that we've resolved the issues. So Ian, the floor is yours.
Okay, well, happy Privacy Day. And thank you for having me on this panel. It's a pleasure to be here. What I want to talk about today is the propagation of metadata. And so if you could pull up the first slide, I think I included some animations that might or might not work, but if you could pull up the first slide, please. If you could go back one. So with the exception of a few very large companies, the rest of us use third-party applications increasingly to power our websites. And during the pandemic in particular, we've realized how many of these third-party tools we use and rely on. So because of the way the modern internet works is pushing functionality more to the edge, we're increasingly reliant on these third parties to power our websites, as well as to track data, to host our services, and they collect metadata. And so my question that I'd like to address is that for the companies that want to do the right thing, it's not easy. And so let's go to the next slide. Do consumers understand what they're opting into and how this data is shared? And do companies understand what they're sharing? And we found pretty much that they do not. So what I have here on this next slide is a scan, and let's see if the animation runs, of a hospital website, and I've anonymized, I don't know if you can get the animation to play on this. Nope. Yeah, that's okay. So I'll just explain. That's fine. You can go to the next slide. So unfortunately, you can't see the animation, but the static image that you can see probably does the trick pretty well. What's going on here is what I brought up is a page that a patient would go to schedule an HIV test. And so you would assume that this page is private, and you would assume that the hospital wants it to be private, and so does the patient. What you see is that the data that's being shared from that website, the metadata, that's your IP address, the browser history, and what links you're clicking on, is shared with over 48 third parties. And the reason this is happening is we've spent a number of years securing internal networks with firewalls and WAFs. And then over the last 15 years, we've created the SSL layer to secure the transport of data from over the network. But that still leaves the entire client side. So for example, since I can't show it, when you go to a site, and I don't want to shame any particular companies because we're all guilty of this, but if you go to a hotel website, probably half the transactions you're doing are not actually with that hotel website, they're with third-party applications. And each one of these third-party applications are operating directly between the browser and this third party that you're probably unaware of. And most of this layer is unsecured. And so years ago, this metadata seemed relatively harmless. These days, this metadata is actually what's building our online personalities. So GDPR has recently recognized that an IP address, location, plus your browsing history and a cookie is enough to deduce quite a bit about you. So for the rest, if you do not have a first-party relationship with a consumer, your identity is built up by these third-party applications and the metadata that they're sharing. So fortunately, attitudes towards privacy are changing. So here's a map from a couple months ago. And what we see is a patchwork of laws that have a lot of common denominators in them. And so I think the awareness is there. People now want to take their vitamins that they've been talking about. People have often talked about privacy. Rarely do they act on it. So the EU, I think, is quite a bit ahead of as well as Brazil, Australia, and a few others, is probably a bit ahead of the US. So on the next slide, I show what's going on in the US. So while the US does not have a single privacy law, and one is probably needed, it has a patchwork of laws. So when you're a company in the US, what you generally do is you decide to conform to the most stringent law so that you can do business across the country. And nowadays, that includes both the California CCPA Act and GDPR. So if we start with the fact that we want to do the right thing, I'd like to posit that it's very difficult to do the right thing. And so right now, what we do have is explicit opt-in consent. That's very good, but that's not completely solving the problem that our data is being shared across many networks. And I think it's hard to say that an algorithm can ignore that you've clicked on, I want to schedule an HIV test. How does that not in some way bias the algorithm? The only way for the algorithm not to be biased is to not collect the data it does not need in the first place. And that's what has to happen. So I think what we're seeing is we have 112 data brokers that I was able to find, and I'm not picking on any one of these in particular. But these data brokers are mostly unregulated and sell access to this data that advertisers buy. And there's a lot of legitimate and legal use cases for them. But at the end of the day, there's two problems going on here. One is, you can just stay on this slide. Don't worry about the animation. Yeah, so there's two problems going on here. One is that this data is actually not very accurate. So for the people who have first-party relationships, like the larger networks and search engines that have first-party relationships, they're able to know quite a bit about you. The rest of the companies are getting less smart about how to target consumers. But the bigger problem with this is that this data, you have no portable identity where the user can go in and one, control what data of theirs is being shared, and two, fix errors. So this data is used for background checks. It's used by people to target you with ads, but worst of all, it's used by anybody that wants to attack you with a phishing attack or target you in some very specific way. They can do so because they can look up so much about you. And by the time they reach out to you, they understand, usually your family tree, the last 5 places you've lived, your debt history. And so at the end of the day, you often hear, and go to the slide, please. You often hear people say, at least in the US, I don't mind trading my privacy. I really don't have anything to hide. And I'd like to bring up that that's not really helpful. First of all, I don't think people understand, again, what they're opting into, but also 90% of breaches last year started with a phishing attack. And when I share my data, that affects everybody in my network. So we're kind of all in this together. And I think it's, I think people are failing to understand how much of their data is being shared and how it's being used. So let me, the animation also didn't play there. So I will close with that. And thank you very much.
Thank you very much, Ian. And I think what we'll do is we'll pivot immediately to Alan to share the perspective of the legal advisor from the newly minted privacy law jurisdiction in Brazil. So Alan, throw it right over to you.
Brent, thank you very much for the organization of this panel. It's a quite interesting topic to speak about privacy and intersection with a consumer protection and competition law. If you could just put the slides on the screen. I'll start the presentation speaking a little bit about the legal framework in Brazil, approach a few cases where consumer protection and privacy law had an intersection, and then giving a few tips on what to do when we are dealing with this sort of intersection between privacy and consumer protection law. Basically, in Brazil, we are a until September last year, a country with sector-specific law. So we didn't have a general data protection law. It came into force last year, and it brought a number of comprehensive obligations. Likewise, the general data protection regulation, it's a pretty similar legislation. Before that, we had a consumer protection which was focused on transparency, avoiding unfair practices, and guaranteeing the offering of safe products in data protection. This means not having a data incident in place. And we have also a specific legislation on antitrust, which is focused on market concentration and predatory business practices and unfair competition. From an authority perspective and enforcement actions, the Brazilian Data Protection Authority was just created a few months ago, right when the LGPD came into force, the Brazilian Data Protection Act came into force. And before that, and until now, we still have most of the enforcement actions focused on consumer protection law and the Internet Act. And all those cases are mostly related to transparency, security issues, and unfair practices, mostly related to data sharing activities within the same economic group or with third parties. That's where the intersection between privacy and consumer protection actually is in those enforcement actions. So far, we have no specific enforcement action based on competition law. The authorities are still studying the subject matter, and we hope that we might have a case within this year or next year. So I'll bring a few cases here just to illustrate how things happen in practice. For example, in 2017, a major bank in Brazil was prohibited of sharing credit card related data within its economic group without the client's consent. That was provided for, the standard agreement of the bank provided for that data sharing activity, and that was deemed by the Supreme Court as an unfair practice. These unfair practices were totally based on consumer protection law. In a second case, I think that you all remember FaceApp, the app that everyone took a picture and you get older. And there are a number of privacy issues related to such app. And in Brazil, a consumer protection authority started an investigation based on the lack of transparency and some data sharing issues related to the offering of such app. Under consumer protection law, we have a joint liability regime. So the company, the app store offering the app is also liable for any unfair practices applied by the app. So Google and Apple were fined by such consumer protection authority because the privacy policy of the app allowed commercial use of the data and certain data sharing activities that were deemed not allowed by the authority or were deemed as an unfair practice under consumer protection law. So again, we see a problem of transparency and a data sharing issue focused on or supported by consumer protection law with the intersection in the privacy and data protection area. Another case, also an investigation in May 2020, initiated by the Consumer Protection Authority, focused on, again, a transparency issue, the app TikTok. The Consumer Protection Authority required some information on what data was collected and for what purpose the data is being used. There are a number of privacy concerns involving the app. So the Consumer Protection Authority, again, based on the Consumer Protection Code, tried to enforce the law. And there's, again, an intersection between privacy and consumer protection. Another case, now those cases are a little bit more focused on security. The Zoom app, the video call application, was the Consumer Protection Authority now at the federal level started an investigation to learn more about some security issues. What were the issues involving the Zoom app, and some suspect of data sharing activities with Facebook. Even data, allegedly the data of users who do not own a Facebook account were shared with Facebook. So there was an investigation focused again on consumer protection law due to the lack of security and possible data sharing issues. I'll jump in this case to the next one. We did have again a data incident involving a major telecom company in Brazil. Again, the Consumer Protection Authority, along with the telecom agency, was investigating what happened when data was exposed. The same thing happened with a major bank in Brazil when there's a leakage of personal data, and all the investigation was based on consumer protection law. So again, we see that there's a number of intersection between the protection of privacy, the protection, the data protection, and also the consumer protection. And lastly, I think that this is the last case. WhatsApp and Facebook also are on the spot when they are dealing with WhatsApp sharing data with Facebook for many different purposes. And consumer protection authorities are always taking the lead to investigate those practices. In 2016, there was an update on the privacy policy of WhatsApp, allowing the data sharing with Facebook. And more recently this year, there was a new update on a privacy policy, also providing for some specifics on the data sharing between WhatsApp and Facebook, and all that was investigated by the consumer protection agencies. And there's a number of rumors or what's going on, a lot of misinformation. So again, a transparency issue and a data sharing issue. We see that most of the recurring topics when you're dealing with the intersection between privacy, data protection, and consumer protection are related to transparency, data sharing, and security issues. In Brazil, we just had a data protection authority created. It should be the prevailing authority to interpret and enforce the data protection law, but it had no enforcement action so far. So the consumer protections, the public prosecutor's office are taking the lead to enforce those actions based on consumer protection law. And again, we have recurring topics: transparency, data sharing activities, understood as unfair practices, and security issues for those applications in the digital world that do not offer appropriate levels of security. We see that in the intersection, we see the authorities do not question, or the consumer protection authorities do not question some of the accountability obligations introduced by the Data Protection Act, such as, for example, conducting a privacy impact assessment, or establishing a lawful ground to process data. That's not the case, or keeping a record of processing. That's not the case. Most of the enforcement actions, when we are dealing with the intersection between consumer and privacy, are based on those three recurring topics that we have mentioned in a presentation. So I think that's most of the most of the topics I would like to cover. It's important to mention that just yesterday, the Brazilian Data Protection Authority issued a regulatory agenda to regulate some of the topics and started its first investigation. It's not related to consumer protection. It's a more broad investigation focused on I think that the major data incident we had in Brazil, over 200 millions of individuals exposed. But we see from the past experience that focusing on transparency, data sharing activities, and security, if you focus on that, you may avoid the enforcement action from now two different authorities, the Consumer Protection Authority and the Data Protection Authority. But that is likely to continue even though the Data Protection Authority in Brazil it's allowed to take the lead on investigations. I think that's all. I'm available to answer any questions you might have.
Well, thank you very much, Alan. And not only are you seeing some recurrent themes in terms of transparency and data sharing, but I think we're also hearing about those recurring themes in terms of the remarks amongst the panelists, especially as it relates to data sharing. Before we go to some questions, and I see that we have one already from the audience, I'd like to turn back to Anna to complete her remarks. We hope that we've resolved those issues. So Anna, I think the last we were talking about is how the magnifying effect of the pandemic on such issues. So I'll throw it back over to you.
Thanks, Brent. That was the infrastructural power turning against me. That I hope it will be okay from now on. I think it was talking about indeed the need to closely look at health data markets, not only from a data protection point of view, but also from a competition and consumer protection point of view. And I was mentioning the fact that it was 1 year ago. I hope, by the way, that these flows will not be too much disconnected from my previous points, which were about the business model trends and the harmful effects for individuals and society. So it was exactly one year ago when, as EDPS, we published an opinion voicing concerns on how corporate entities were appropriating health data for purpose that we found covered by business secrecy. And as said, this should not only be a concern, in fact, for data protection authorities, but for other regulators. And why so? Because we have been seeing this. The Pandora box is open and digital players are, in fact, conquering the, until now, unexplored almost world of health data markets. I'll go shortly to my third point. Against all this background, I believe regulator scrutiny must remain high and must, importantly, grow in foresight. Of course, my perspective is very much about synergies, so exploitation of synergies between fields of law, not because I don't see the collusion, but so the clashes, but because I believe that the first overcome the second. My third and final point is, in fact, that regulators must really team up and most importantly, must pursue courageous application of the law. And by regulators, I mean all regulators. And why is this so? We heard it from during the Digital Clearinghouse panel of this early afternoon. It's a challenge of knowledge here. There's no way that regulators from one field of law only will be capable to really grasp the complexity of the digital ecosystem, even in its own field, without the support of the other regulators. So understanding digital markets and addressing the systemic issues in there require that regulators in privacy, data protection, competition, and consumer protection alike cooperate. And how is this possible? Well, data protection authorities, and I'll dive into it shortly because I'm not sure I will be able to do later, to say that later. Data protection authorities can support competition authorities in defining theories of harm that are appropriate to the times we live in. And on the other way around, enforcement of data protection is crucial to inject fairness in the markets and make them more competitive. But we need that courage, we need that bravery. To get more technical for a second, there is one particular scenario on which regulators from different disciplines of attention should actually focus on, I believe. Dominant companies exploiting all relevant input, so say data and the rest, to anticipate market trends and leverage their established power in one segment of the market to enter and entrench dominance in other segments. Well, this scenario, which is of course just an example among the many, touches all regulators responsible for digital economy. Data protection, because the vehicle is tracking. Competition, as the competitive advantage given by such behavior as an exclusionary potential. And consumer protection, if dark patterns are involved and if an attack to the fairness of condition is at stake. To sum up, regulators must really act with the bravery and the courage that these times require, I think. Never forgetting that the regulatory choices of today and also the lack of regulatory choices of today will really determine the world of tomorrow and will affect future generations. So with that, I stop, Brent. I really thank everyone for the attention, and I'm looking forward to the discussion.
And I think that's those are good words about collaboration in terms of talking about the courage, and the courage also involves being able to understand each other and know each other and respect each other's jurisdiction and the intersection, so that you can both work together towards a better outcome. Anna, I was going to just start with you on some questions for all of the panelists. And as I recall, you were on the team of our late great friend Giovanni Butarelli, who I would describe as a prophetic pioneer in exploring these issues, including he had created the idea of the digital clearinghouse. So I was wondering, historically, when did all this reflection start? And has this regulatory collision evolved in the form that was anticipated perhaps 5 years ago?
Thank you, Brent. I'm really glad that you mentioned Giovanni and his role and the digital clearinghouse. By the way, it's great that we are having on the very same day these two panels discussing these issues, these aspects, because this is a truly remarkable result compared to the situation and the level of awareness and understanding that we had when this discussion was in fact started in EDPS at the European level. So a few information as a background. The Digital Clearinghouse is a voluntary network of authorities gathering, in fact, regulators from data protection, privacy, as well as from competition, consumer and media regulation, launched by EDPS in 2016. And now brought forward under the leadership of University of Namur and Tilburg. We had started investigating this interplay and the possibility for regulatory synergies some years before that moment. And actually, to respond to your question, the idea came really from observing different authorities applying their respective fields of law in strict silos. A luxury that regulators cannot really afford today, given the monopolistic conditions that individuals are confronted with, the complexity, as said, that underpins digital and online services, and the interdependency of these aspects. So the idea was to create a neutral forum for discussion and exchange of practices. Well, slowly and surely throughout the years, we've seen terrific progress in the understanding of why, for example, privacy is a competitive parameter. So, for example, has privacy degradation might be a problem, is in fact a competition problem, or progress on the no monetary and societal costs that individuals and societies bear in exchange for the attention economy services. So the progress now, to answer the second part of your question, well, in Europe, we are at a crucial turning point with proposed legislation. DMA, DSA, they've been referred a lot during this conference, which in the Brussels jargon stands for Digital Markets Act, Digital Services Act, which are finally acknowledging the responsibility of some very large players and the aim to, in fact, make markets fair and contestable. The thing is, we have to get this right, because there will be also interplay with the fundamental rights legislation at place. It's a legislation that, in fact, will inevitably include some cross-disciplinary elements. And I think that future cooperation to, of course, take into account those elements. In short, I believe that what we have, it's a good starting point, but it's time now to take it to the next level. What we probably need is a more structured and institutionalized form of cooperation to achieve the outcome that I was envisaging. And I'll stop for now.
Well, thank you very much, Anna. And I see a few questions, and we have 15 minutes, so we'll try to kind of get through what we can. Erica, a question from the audience. That you mentioned mergers, and one of the problems of competition authorities was that there's no relevant market for data. Has that changed in any way? Are there more efforts to define a relevant market for data in merger analysis? That's a really good question that I've been asking myself.
Thank you, Brent. Thank you from the audience for that question. I think this might be something that you think about differently on the antitrust and privacy side. So it's a good example, because relevant market definition for antitrust authorities has a very specific meaning. And I don't think it has changed dramatically from the traditional economy to the digital economy. It's still focused on substitutability of services. And the tendency has not been to define data markets so much as something narrower, specific markets for products and services, like professional social networking and the Microsoft LinkedIn merger, which I mentioned already, online messaging as a relevant market, or display advertising or search advertising as relevant markets. And I don't think there has been a particular insurmountable barrier to doing that in antitrust analysis. I think it's gone along fairly well. I think the challenge, if I can reframe a little bit from the antitrust perspective, has been that many of the products and services are zero priced on one side of the platform. So what I mean by that is consumers don't typically pay for search or social or messaging services. And so that has created some challenges for antitrust analysis, because it is classically focused on a small but significant non-transitory price increase as a way to identify substitutable products. That doesn't quite work. We have to adapt that a bit for the digital economy to measures like quality decreases instead of price increases. And the OECD has been doing some great work on that. I commend their reports from around 2018 on zero price markets if you're looking to understand that issue more.
Thank you very much, Erica. I'm going to go directly to Alan with another question from the audience. You mentioned that in Brazil, Apple was fined because it allowed its app store and in its app store an app that violates privacy principles. So, on what basis was Apple fined? And was App Store, was that just medium? And will, for example, a cloud service provider be fined because one of its clients hosted in its cloud platform some content or apps that violates privacy principles?
Great question. I think that in privacy laws in Brazil, not those related, I think that the general data protection law, we have a specific liability regime that would never allow this sort of penalty being applied to an app store, for example. If you get division of Consumer Protection Authority, which is, sort of a different vision, super protective to consumers. They try to impose joint liability to all of those that are part of the chain of that offers a specific product or service, in this case, a specific app. So that was based on that a specific liability regime that is provided on consumer protection law. I think that specific regime would never apply to a cloud service, for example, for specific reasons that cloud services not all the times have the control of what is actually included in the platform or included in their services. They should not have the ability to see that information and to control that. I think that the level of controllership is key here to understand how can you impose liability to the different stakeholders involved in the offering of a specific product or service. And I think that the Data Protection Authority is likely to give a more neutral view on the liability regime, other than consumer protection authorities that are normally super protective to consumers.
Thanks, Alan, for that. Ian, I think not only you mentioned, but others made reference to the challenges associated with the infrastructure of the digital economy and how it may create the conditions for market power. So here's a magic wand for you to do a redo to the virtual infrastructure of the digital economy in a manner that promotes competition while protecting privacy. So what world would you create?
I think Erica brought it up from the beginning. A portable identity wasn't built into the internet, and it's very difficult to get that started. So imagine that we all had to have our identities in one place, and if you wanted to use our identities, you had to retrieve it from that one place. So if that had been built into the internet to start, we would have access and control over our data. And what that would do from the commercial side is it would make, I think, our data more accurate. And it would certainly give us control over mistakes and the sharing of the data. The problem in creating that is, well, we have a magic wand, so we don't have to have a problem. But in the real world, I've seen 25 companies try to build these digital clearinghouses, and they all fail for various reasons. So it really does have to start with a push from the regulators. It has to be enabled by them, or it has to be enabled by what Apple's doing. But one way or another, it's either going to be done by a private company, which I don't think most people are going to be comfortable with, or the regulators. But in this world, I think you would accomplish many things. First of all that sharing of that third-party data that I was unable to show. If I could wave a magic wand and get the video to work, I would show it to you. But all that data being shared would suddenly become worthless. So on the supply side, you would basically remove, on the demand side, you would remove the value of collecting all that metadata, because you could have direct access to what the consumer actually wanted. So if I could wave a magic wand, I would build portable identities into the protocols for the internet. And I would disable data collection from all cloud applications.
Excellent. That'd be a pretty powerful magic wand.
Well, and as I said, I've seen many companies try to do it, and the incentive structure doesn't quite work, right? Because I've seen companies try to pay you for your own data. Brave was a browser that tried to basically give you full privacy. Even Mozilla and Firefox weren't able to compete in this market, and they were not small. So I don't see an alternative. We can't just keep sharing data the way we're doing through cloud applications. It's becoming untenable.
Thank you, Ian. I noticed that we're coming close to the end of our time, which is a bit of a shame, because we have a lot to talk about. I think that in terms of the points being made, we do have a reaction. I think Anna wants to share some of her thoughts, and then as well, we will certainly not end this panel without giving everyone an opportunity to provide their big, huge takeaways. But Anna, you wanted to react to one of the thoughts shared.
Just to thank the panelists for the insights shared. I think many of the things which were said are interesting in many ways and from different perspectives. But maybe just quickly, so that I don't take time out of the final interventions from the rest. I think the data sharing, data access dimension that it was referred to will need to be closely looked at. There might be doubts that at such this kind of remedy might be able to restore fairness in markets if we're not able to contest and change the business model beneath. And absolutely agreed with the lack of awareness from consumers in what's happening around in the digital ecosystem that we must tackle. And very shortly on privacy. Well, privacy is often misused for many reasons and from very different angles. We should pay attention to the narrative also here, which is built and around it. I just wanted to conclude by saying that. Thank you.
Thank you very much, Anna. So now, like lightning round, so let's bring it down to a 30-second big takeaways. Erica, let's start with you.
Sure, thank you, Brent. So I think the big takeaway here is we are seeing on the antitrust side just a flood of cases against digital platforms. But a wise antitrust enforcer here once said, everybody likes to catch them, nobody wants to clean them. That's like fishing. It's difficult to design the remedy once you've won your case. So the devil's in the details, and we've heard that already from the themes of this panel today. And what we have on the horizon here is antitrust remedies that need to be designed in a new world of data privacy. And we're going to have to emphasize cooperation and collaboration between those regulatory spheres. Thanks, Brent.
Thanks very much, Erica. Ian?
Well, given that Google just got fined $50 million by GDPR, and it's not just the biggies, I'd say that it's time to make sure you understand and can see and control all the data that's coming and going from your site. And until you can do that, I would be very uncomfortable as a business.
Alan?
No, thank you. Very important, two key takeaways. Very important for regulatory agencies to speak with each other, Data Protection Authority, Consumer Protection Authority, and Competition Antitrust Authority. And from a company's organization perspective, always important when dealing with data to look into the privacy and data protection regulation, but also to consumer and competition law, as this is a complex issue and there's a lot of intersection between those areas.
Good point. And Anna?
Glad to see the awareness around this topic has grown a lot. We need to change the underlying problems, endemic problems that we have in the digital economy, and there's no chance that we will do it if regulators from different fields of law do not team up and cooperate. So we must be courageous and pursue this cooperation to the next level. Thank you.
Thank you very much, Anna. And I think on that, and in responding to Stuart Dresner's question of which national data protection authorities have been most supportive of their national competition authorities and vice versa, we've heard about the need for collaboration. And we can say that from the Digital Consumer Working Group, we are seeing more and more examples of collaboration. We've seen in the UK a more general commitment and a informal network between the CCMA, the ICO, and the telecom areas in terms of working together and understanding each other. So I think in a very hopeful way, the fact that these worlds are colliding is being followed by an awareness and a recognition by regulators that they have to kind of work together. So let's leave on that hopeful note. This is obviously a topic that is of extreme interest and relevance, and I know that a topic that is going to be continued in other privacy conferences as well as antitrust conferences. So keep an eye out for it. I want to really thank our expert panel for coming together to share their views, and for our technical people to helping to allow us to share our views and resolve some problems. So with that, I've just been told I have 30 seconds. So I think we'll wrap it up right there, and thank everyone, and hope you have an interesting evening and good and afternoon wherever you are. Thank you very much.
Thank you.
Thanks.
Thank you. Bye. Thank you so much.